Okay, we started our live stream. You may now share your screen if you want.
Yes. I see my screen sharing has not been authorized. Maybe you have to make me a co-host. Ah, now it works.
Yes, okay. Okay.
Does this look good?
Yes, it looks good. Thank you. Okay. We will start our conference now. Good afternoon, honored guests. It's a true pleasure for me to welcome you all to Judicial Imperialism and the Permanent Court of International Justice's interpretation in 1923's Treaty of Lausanne regarding the Mosul Vilayet question. And this conference is organized in cooperation with the Department of Political Science and International Relations and Sociopark. Now, I would like to introduce our speaker, Dr. Valentin Yutna. He's a graduate of Oxford University, Georgetown University, and Cambridge University, where he completed his PhD. He is licensed to practice law as an attorney and counselor at the law in the state of New York. Previously, he taught inter alia European Union law, international law, and jurisprudence of multiple Oxford colleges as a stipendiary lecturer in law at Pembroke College. He mainly works on foundational research related to nature and the fundamental principles of international law. Firstly, I would like to sincerely thank Dr. Yutna for accepting our invitation. To begin our conference, I yield the floor to our head of department, Professor Dr. Mehmet Akif Okur, for him to deliver his opening speech. Thank you so much.
Thank you, Gülay. Welcome, Dr. Yutna. It's a great pleasure for me to see you among us as a guest of this joint event hosted by both the Department of Political Science and International Relations and Sociopark. My colleagues and beloved student interns have devoted a great deal of effort to the organization of this program, and we are particularly grateful to them. As we all know, the Treaty of Lausanne has a memorable place in Turkish history, and scholarly research on it always takes an academic interest. And next year, we will celebrate its centenary. But I think in Dr. Yutner's article regarding the Treaty of Lausanne, there is another point we should not overlook. It is about the cumulative results of the politicization of international courts. And this frightening tendency influences the perceptions of international actors about the foundations and nature of the world system and directs them to think that there is no practical way of protecting legitimate rights and interests other than the means of violence. Unfortunately, we are currently living in an age of instability caused by widespread transborder armed conflict, but their numbers and intensity are growing. And when I ask my students whether they believe in international law as a way to find solutions to these conflicts, most of the time I get negative responses. But a century ago, following the horrors of World War I, the institutionalization of international law was a source of hope for war-weary humanity. So how did we get here? What explains the erosion of the prestige of international legal institutions? We can list several possible answers. There is no doubt that one of them is the politicization of international courts. And certainly, the Permanent Court of International Justice's advisory opinion on the interpretation of the Lausanne Treaty is among the early significant examples of such decay. Dr. Yutner's article captures the heart of this debate from the perspective of international law. And luckily, today he is here with us. Dr. Yutner, the floor is yours.
Thank you very much, Professor Okur, for these words of introduction, and Ms. Alkan also. It's an absolute pleasure to be here. I'm very grateful for the invitation. I only regret that I cannot be with you in person, because as I mentioned earlier, Istanbul is one of my most favorite places to be, and I hope there will be an opportunity in the future to continue our discussions, maybe in person in Turkey. Today, as Professor Okur mentioned, the topic of my talk is the advisory opinion concerning the interpretation of the Treaty of Lausanne. And my plan is to speak for about 20 to 30 minutes so that we have plenty of time at the end for questions or comments that you might have. I should also mention maybe that as an international lawyer, my focus is very much the law, and it's a little bit of a micro study of how law and politics interact, but it is quite neatly tied to the specifics of this case. And I look forward to maybe considering the wider context also in our questions towards the end. This title, you might think, sounds a little bit dry or maybe complicated, but it is at heart about the so-called Mosul Question. And the Mosul Question arose after the end of the First World War. The Ottoman Empire had collapsed or it was a period of collapse, but it had definitively collapsed in the early 1920s after the end of the First World War, which meant that British forces moved to occupy this area, which you can see here on the map, the green area, the Mosul area. And subsequent to this occupation, the British forces and the newly established state of Turkey entered negotiations concerning where exactly the boundary should be drawn between Turkey proper, the state of Turkey, and between Iraq. Iraq wasn't an independent state at the time, but was a mandatory or a mandate under the control of Britain. That's why, even though the question concerns the boundary between Turkey and Iraq, it was Britain that was doing the negotiation with Turkey. These negotiations concerning this boundary proved to be quite difficult. It was a very controversial and complicated process, which means when in 1923, the Lausanne Treaty was signed, the parties to that treaty, most importantly, Turkey and the UK, left this question open. They didn't settle the boundary. They settled all kinds of other boundaries, but this one was left open. And the reason it was left open, or the reason why it proved so controversial, relates to a few special features of the Mosul Vilayet. The Mosul Vilayet, or the Mosul area, which you can see here again colored in and with modern boundaries superimposed. So you have Turkey here, Iraq here. This area was, or still is, very rich in resources. At the time, so the 1920s, cotton was a very important economic factor in the region, but now also oil, of course. So it was a very resource-rich area, which made it very desirable to have by people on both sides of the border, the Ottomans or then the Turks and the British. It's not entirely clear how many people actually lived in the Mosul Vilayet. You can find estimates that range from 300,000 to 800,000, so quite a big range here. It depends a little bit also on how one delimits the Mosul Vilayet, but this is a rough estimate of how many people live there, and the people that did live and in part still do live in the Mosul Vilayet are quite diverse, which also made it difficult to put the area to just Turkey or to just Iraq. There were diverse languages spoken: Arabic, Syriac, and Kurdish, for example. Those are just 3 examples. And the diversity of the languages was also reflected in the diversity of religions. There were Sunni Muslims, Assyrian Christians, and Jews also, with the Sunni Muslims being the majority. All of these factors meant that the area was claimed, well, yeah, was a desirable one, that it was claimed by Britain and Turkey. Britain wanted it predominantly to maintain a stronghold in the area, and also to keep make it possible to access the rich oil resources in the area. And Turkey claimed it based on ethnic ties, religious ties with the area, and based on the fact that this area used to be part of the Ottoman Empire. I should also acknowledge that there were 2 other factions that claimed this area that normally are not receiving much attention, because they were not players on the international scene in the same way that Turkey and Britain were. And those were the Kurds, the Kurdish people that live in that area and ideally wanted to have their own state, but also the Hashemite king Faisal of Iraq, who was also interested in having this territory for himself. But the most important players, and also the players that we are going to look at today, are Britain and Turkey, of course. And down here, before I move on, I should point out that this is a picture from Mosul, the city of Mosul, the capital of the Vilayet, from the 1920s. So this is what Mosul would have looked like at the time. Now, the arrangement, as I mentioned, the Treaty of Lausanne left the question open, and the arrangement that was, or the agreement that was concluded in the treaty was the following. In Article 3, the parties agreed, and the parties are most importantly Turkey and the UK, but there were also many others. The parties agree that the frontier between Turkey and Iraq shall be laid down in friendly arrangement to be concluded between Turkey and Great Britain. And Great Britain comes in here, even though it is about Iraq, because as I mentioned, Great Britain is the mandatory power of that area. So friendly negotiations should be conducted in order to solve the border question. You can see that here quite neatly. You have here on this map all of the boundaries that the Treaty of Lausanne agreed. And then you can see here this boundary. I hope you can see my mouse, my cursor. In any case, otherwise in the east of this map, you can see Council of the League of Nations. You have a lack of a boundary here. So with respect to that area, the treaty also provided, if it doesn't work out, to find a good solution by negotiations, then the dispute shall be referred to the Council of the League of Nations. And the question, of course, is what happened following the 1923 treaty? Did they conclude, or were they able to conclude where that boundary should be by means of friendly negotiations or not? And of course, as you might have guessed, since we are talking about a case, it didn't go as smoothly maybe as one would have hoped. So the parties, Turkey and the UK, fail to agree on a boundary. Both of them insist that they want to keep the territory, which means the dispute is then referred to the Council of the League of Nations in accordance with Article 3.2 of the Treaty of Lausanne. The Council of the League of Nations is a little bit similar to, was a little bit similar to the General Assembly, no, to the Security Council of the United Nations. So it was a smaller council of powerful states made up of 4 permanent members: the United Kingdom, France, Italy, and Japan. Those were the 4 permanent members of the council, and then initially 4 and later 9 members elected from the Assembly of the League of Nations. So this council, made up of the UK, France, Italy, and Japan, and a few others, was confronted with the question of where that boundary should be drawn. And the reason the League of Nations Council passes on a question that then leads to this advisory opinion that I'm focusing on today was that the council wasn't sure if they were authorized to settle the boundary question without the consent of the parties. In other words, can the council decide where the boundary should go without consulting Turkey and the UK? Most importantly, without consulting Turkey, because as we have seen, the UK had a seat on the council, and essentially everyone on that council was an ally of the UK. So the key question was, can the council set the boundary without consulting Turkey or even against the veto of Turkey? And the article in question, as you just saw, which gave rise to that question, was the one that I reproduced here, Article 32. In the event of no agreement, the dispute shall be referred to the council. But what does that mean, shall be referred to the council? Does it mean the council can just make it decided by itself, or does it mean the council needs to find a solution that considers everyone's views? When considering how to answer this question, the PCIJ said they want to only look at the intentions of the parties that concluded the treaty. So that is most importantly the UK and Turkey, and at the drafting history, at nothing else. That's what the court explicitly states in its judgment. It says we will only look at the intent of the parties and at the drafting history, nothing else, no other treaties or international norms, just the intention of the parties. And I'm stressing this because we are going to look at the intention of the parties. And I think the conclusion the PCIJ reached probably conflicts with the intentions of the parties. But let's have a look at the intentions of the parties first. And in order to find out the intention of the parties, we have to travel to Lausanne, to this very nice hotel, which still exists, which is where the conference took place that later led to the Treaty of Lausanne. And we must look at the minutes of that conference. So when preparing the text that I think maybe some of you have seen and that Professor Okur had referred to, when I wrote this little text about the conference, I looked at the minutes, at the protocols, at the reports from those days when Lord Curzon and Ismet Pasha lived in the hotel and went back and forth between their rooms and between the coffee room, between the restaurant. It's quite exciting to read if you're interested, and what kind of messages they exchanged. And what one can see by looking at these minutes and the messages is the following. So in the morning of the 23rd of January, 1923, Lord Curzon, the British representative, sends a note to Ismet Pasha, which reads, the League, so the League of Nations, should be entrusted with the impartial examination of the frontier dispute. So that doesn't tell us super much just now, what exactly that means. But in the afternoon of the same day, Lord Curzon adds a note and has it delivered to the rooms of Ismet Pasha, where he says, a decision by the League of Nations concerning the frontier question will have to be unanimous, so will have to be reached at with the consent of everyone, which means that no decision can be arrived at without the consent of Turkey. So Lord Curzon here on the afternoon of the 23rd of January assures the Turkish delegation that what they are proposing is that there is a mechanism where if the two parties bilaterally cannot reach a conclusion, the whole League of Nations will get involved. But in any case, any decision that will be reached will have to be reached with Turkey's consent. In other words, Turkey could veto a decision by the League of Nations Council. About a week later, Lord Curzon presents a draft agreement. That's the draft agreement of the Treaty of Lausanne, which he says contains no surprise or menace, so nothing negative from Turkey's point of view, and nothing which Turkey doesn't already know. So in other words, this draft agreement mirrors or reflects the assurances and the statements, the discussions that Lord Curzon and Ismet Pasha have had throughout the last few days. And there's nothing substantively added between the 23rd of January and the 31st of January. If you look at the minutes, they discuss all kinds of other things, but the Mosul question is not changed between the 23rd and the 31st of January. And in order to also dispel any kind of doubt, Lord Curzon also says the League would be resorted to in the manner originally proposed, meaning Turkey's consent is necessary. A few days or a few weeks later, in March, you can see the delegations here, Ismet Pasha down here with the Turkish delegation. A few weeks later, in early March, Ismet Pasha agrees and says, all right, territorial questions should be settled in accordance with the proposal by the UK and the Allied powers. But he suggests that the wording should be softened a little bit. It should be made a little less precise. And he says, the dispute shall be referred to the Council of the League of Nations. That's how Article 3.2 should be worded. And this is, if you remember, if we go back, no. If you go back, this is also, dispute shall be referred to the Council of the League of Nations. So this is exactly the same as what Ismet Pasha is proposing here. This is a Turkish proposal based on the Turkish understanding that no decision can be reached without Turkey's consent. And he prefers, Ismet Pasha prefers this wording over the previous wording, which was the frontier should be fixed in accordance with the decision of the Council. So he wants to soften that a little bit and say it should be referred to the Council, whatever that might mean, instead of the Council being authorized to fix it. The UK and the Allied powers accept this proposal, evidently, because that's what the treaty looks like in the end. So it seems, sorry, it seems from the brief discussion of the draft history that there are at least two things that are very clear. One, the parties explicitly discussed the question of consent. It was very important for Turkey that this boundary question couldn't be settled without the consent of Turkey. And it was also made clear, or it was made understood that everyone is on the same page in that regard. So consent was discussed and the importance of the Turkish veto were discussed. Those are the two important things to keep in mind. They are important to keep in mind because this is not the conclusion that the Permanent Court of International Justice reached in the case. So we now jump to 1925. The dispute has been referred to the Council. The Council has asked the court, so what does it mean? And the PCIJ, the court, you can see the Peace Palace here on the right, says the Council of the League of Nations can settle the boundary without the consent of the parties. And I worded this in the abstract here or in general terms, but it is important to keep in mind that the UK sits on the Council and that most of the members of the Council are essentially the diplomatic friends of the UK, whereas Turkey has an ad hoc member in that council, but is the only one that was on the opposing side of those states in that council in the First World War. So legally, the council does not distinguish between the parties, but de facto, the UK had a lot more say in those proceedings. In any case, the Council of the League of Nations, the PCIJ says, can settle the boundary question, and it can do so because the PCIJ says the parties, Turkey and the UK, intended to give the League of Nations Council special powers, extraordinary powers that go beyond the powers that the Council normally has. And it also says that the parties explicitly intended to depart from the unanimity principle, as in the principle that any decision the Council makes requires the consent of everyone. So they say, generally, yes, we can only make decisions as a Council if everyone agrees, but in light of the drafting history, this is not what the parties wanted. And I think there are at least three things that are surprising about this conclusion. One is that the court itself acknowledged that Article 3 is vague. So Article 3 and Article 3.2 in particular does not speak for itself. It is an article in need of interpretation. It doesn't clearly disclose what the parties intended. So in light of that fact, it is surprising or extraordinary or maybe astonishing that the court reaches quite an extreme conclusion, namely that you can settle the boundary against the wishes of one of the parties involved. The second reason that this conclusion is surprising is that the drafting history that you've just seen, and it's of course, it's a condensed drafting history, but it captures what was going on. I didn't leave out any contradictory information. The drafting history clearly shows how important consent was to the parties and how the Turkish proposal was the one that ultimately was accepted. And the Turkish proposal being one that wanted to lower the authority or soften the power of the League of Nations. So that is very difficult to square with the conclusion that the parties intended to confer extraordinary powers upon the League of Nations Council. It's also surprising because the court itself acknowledged the importance of the unanimity principle. So they said it is extremely important in the judgment that everyone agrees and that we make decisions by consensus. And at the same time, while pointing this out, they are saying, well, in this particular case, we depart from that principle. And I have an idea maybe why they do it. But for now, I think it's important to just acknowledge that there's a tension. And on the next slide, let's see. Yeah, I'm considering why maybe the court reached this conclusion instead of following what I think the drafting history suggests. And there are two clusters of assumptions that the court makes. One, judicial assumptions or assumptions concerning the operation of law. And one set of assumptions are related to political questions. Regarding the judicial assumptions, they say clearly what the parties intended was an arbitration, a legal dispute settlement mechanism. And that means that the consent of the parties cannot be important because a legal dispute settlement process is supposed to work even when the parties don't consent. Otherwise, one wouldn't go to arbitration. However, one could respond to that argument that one could say, well, why not? Why couldn't arbitration be consent-based? Or why even make the assumption that arbitration is what was wanted? Because if you say, PCIJ, that you are only looking at the intention of the parties, it's very difficult to deduce from the intentions of the parties in the negotiations that it was really an arbitration that was wanted. If that would have been the case, the parties could have written it into the treaty, but they didn't. So maybe it is not right to assume that the parties wanted a legal arbitration. And therefore, it's also problematic to conclude that because they wanted arbitration, consent doesn't matter. So this is a very problematic argument, I think, for the court to make. The second legal assumption that the court makes, and they are quite explicit about this in their judgment, is that they say, well, the consent of Turkey and of the UK can't matter that much, because you cannot be a judge in your own case. And if you would give Turkey a veto, then that would mean that they are a judge in their own case. But again, the assumption here is that the parties wanted a judicial legal settlement as opposed to a political settlement. I think in light of the drafting history, it is very clear that what the parties wanted is a political settlement. And while it makes sense in a legal context, maybe, to say you cannot be a judge in your own case, in a political context, that makes no sense. Because in a political context, you expect those who do the negotiations or those who represent interests to be intimately connected with the interests they represent. To say you cannot be a judge in your own case would be to say, like, Erdogan cannot represent Turkey's interests. Erdogan is the representative of Turkey's interests, and that has nothing to do with him being a judge in his own case. So therefore, I think that assumption too is problematic. You cannot dismiss the Turkish political interest in defending its interests and in saying we would want to have a veto by saying you can't be a judge in your own case. That just doesn't work. Apart from these judicial assumptions, there are also political assumptions. And I just put one here also in the interest of time that is fastly advancing. But the political assumption is probably twofold. One, that it is the League of Nations Council, so a group of mostly allied powers, victorious powers after the First World War, situated far away in European capitals, that knows best how to draw that boundary, that these sovereign states sitting around a table like the one that you can see here on the picture, that these people, they know best how to solve the boundary question. That is clearly an assumption that the court is making. And that assumption has a flip side, namely that the people on site, or the people actually living in the vilayet, probably do not know best, or at least are of less importance. And when we spoke briefly just before the lecture started, Professor Okur pointed out that there were commissions and attempts to find out what the people actually want. And it turned out that the people were much more in favor of a solution that would have allocated the vilayet of Mosul to the Turkish state. But these views were just not deemed as important. So that is clearly also an assumption that informs the court's view. And to some extent, one can say it was a different time. Nowadays, maybe rights to self-determination of various kinds might mean that one would go about it differently, but to some extent, it is also difficult to argue that it is a coincidence that the allied powers, those powers allied with Britain, sitting in that council, sitting on the bench of the Permanent Court of International Justice, would reach a conclusion that favors ultimately Britain. Now, what happened afterwards, after the case? A very famous international lawyer, Herr Schlautepacht, he called this opinion, this case, a bold piece of legislation. This was at the time when the decision came out. So there's a contemporary view. And two things are important, I think, about this phrase, both bold and legislation. Bold indicates that the judges maybe did something that required a certain amount of courage. But legislation, more importantly, indicates that they went beyond the application of the law, but straight into lawmaking, because that's what legislation means. Courts do not normally legislate, at least not international courts. Common law courts, my home jurisdiction is England, and in England, that judicial legislation or in common law jurisdiction generally is something you can see, of course, but on the international plane, courts should normally not legislate. Bold is the opinion because the PCIJ endorsed a non-consensual fixing of boundaries in, and I said here on the slide, in apparent disregard for the parties' intentions, also in apparent disregard for the drafting history, and in apparent disregard of the views of the people on the ground. Turkey, as a result of this outcome of the case, was understandably displeased and withdrew for a while, for about 5 years, from further negotiations of the question. It has also been pointed out, and I think in the subsequent cases, the PCIJ got a bit more careful here, that it was a problem that the court opted for an interpretation of Article 3 that was particularly burdensome or particularly consequential for the parties involved, even though the PCIJ itself has claimed that it normally, when there is a vagueness, opts for the least burdensome interpretations, and it didn't do that. So that's another consequence that I think they tried to correct later on. And that brings me to my last point, namely that the assessment overall of this case, it probably allows for the conclusion that here the court did stray from its judicial mandate into policy making and gave in to the pressures of the times, which means essentially gave in to the interests and pressures of the United Kingdom in light of the UK's interests, mostly of an economic nature, but also of a political nature in the Vilayet of Mosul. But at the same time, it is not black and white. So it would be too easy to say that the PCIJ on the whole maybe was incapable of drawing a clear distinction between law and politics, because there's the Lotus case, which I think many people and law students in Turkey know about. The Lotus case arose a few years later between Turkey and France and concerned the collision of the Lotus, which you can see here. Unfortunately, there is no picture of the Bozkurt, the Turkish ship that the Lotus collided with, because it sank. But this was a very important case, not just for Turkey, but also for international law, because the Permanent Court of International Justice, the same court, more or less the same bench that had found against Turkey regarding the Mosul question, very firmly sided with the Turkish arguments, and not in a political sense, but in the sense of siding with the legal arguments when it came to settle the Lotus question. I very much hope that maybe I can get the chance to talk to you about the Lotus another time. It's a case I'm very interested in. But today was, of course, about the Treaty of Lausanne. And I think, as Professor Oko, as you pointed out at the beginning in your introductory words, we do live in times where international law is under particular pressure, and where one might wonder what international law's ability can be to safeguard the interests of those who might not be the most powerful, or those who are disadvantaged in some way. And I think the case of today is a good reminder that this function of international law works only if, first of all, the powerful states, Russia, the US, Turkey, Germany, whoever it is, the powerful states need to comply with international law, otherwise it doesn't work. But most importantly, maybe, or even more importantly, courts too, when they apply the law, need to make sure that they stick to the law and don't mix it with politics. Because if they do, and if the PCIJ, as I argue, gave in to the political pressures, then the whole utility of international law and its authority, and also our respect for international law, is undermined. And that, I think, ultimately nobody benefits from. And you could maybe go even one step further and say that to some extent, the conflicts that still exist in the Middle East today, not just regarding the Mosul question, but regarding all of the boundaries that were drawn after the end of the First World War, show that that approach was not particularly sustainable, and that maybe it would have been better to take a bit more time to consult the people on the ground and to stick to the principles of international law that were announced in the wake of the end of the First World War, including self-determination, for example. Yes, but I think I'll leave it here. And I thank you very much for your attention and welcome any questions, comments that you might have.
Thank you for this informative presentation. And now we will entertain questions from our guests, if we have any.
Can I ask a question?
Dr. Laçin İdilöztü,
Hello, everyone.
my colleague from the department, and the floor is yours.
Thank you very much. Thank you very much, Dr. Jötner, for your interesting presentation. You clearly illuminated the linkages between politics and the judiciary. The Musul question is an archetypical example of judicial imperialism. Even if the Turkish and Iraqi border is completely different from colonial borders, imperialism, great power politics, and unequal power relationships were at play in the design of this border. My question will be somewhat out of scope. If we look at the development of international law, we see a lot of efforts to justify colonialism, especially in the 17th and 18th centuries. People in the colonized areas were labeled as primitive people who lacked agency. So this mentality carried on from generation to generation. If you look at the International Court of Justice today, we see that it mostly targets African states. It is accused of targeting African leaders while turning a blind eye to perpetrators in other areas. So if you look at the functioning of international law today, especially jurisdictions of International Court of Criminal Courts, could we say that there is judicial neo-imperialism at play in today's politics and the judiciary? Thank you.
Yes, thank you very much. Yes and no, or maybe yes, but maybe one also has to give the, I'll restart. There are patterns today with respect to the practice of the International Criminal Court and the investigations they launch that seem to suggest that there is a bias or that there are some conflicts that the world community cares more about than others. Compared, for example, to what the United States do, or what Israel does, or what Western states do, or Russia, for that matter. I'm not sure whether or whom to attribute that most properly true. You could say this is a problem of the judicial institutions as such, or one could say it is a problem of the political actors that instruct the judicial organs to do specific things. Because my impression is that I think the judicial organs themselves, the ICC, the ICJ, the PCA, they are doing good work. And they often attempt to launch investigations in areas where it is also difficult for them. And then they are met by sanctions. For example, the US imposed sanctions on the ICC prosecutor. So the prosecutor wanted to investigate, but the US said, we will impose sanctions on you. So I think the judicial organs that we have, I think they are reasonably robust, more robust than the PCIJ was, but the political pressures are, of course, intense. And I'm not sure that we have sufficient safeguards to protect judges and legal institutions from these political safeguards always. So I would agree with you that there are these tendencies, but I'm hopeful, or I'm thinking, or maybe I'm too optimistic, but I'm thinking that the legal structures are not to blame for that. I think it is the politicians and the sovereign states that often interfere with the legal structures.
Thank you.
Are there any more questions from our guests?
I want to add something, Dr. Götner. Thank you for this presentation. For the presentation, I mentioned about the Inquiry Commission's report on Mosul Vilayet, and concerning regarding the thoughts of local population, there are significant interpretations we can extract from the report. First of all, the Turkish thesis was that League of Nations, under the auspices of League of Nations, a referendum, a plebiscite should be made to decide the fate of the Mosul Vilayet. And the British side refused this offer by saying that, with the words of Lord Curzon, only the educated people can decide their fate through plebiscite, because the Kurds living in the Mosul Vilayet are uneducated people. So this option cannot be used in Mosul Vilayet. And Turkey replied by saying that if you mean that they do not know how to write or read, so just use the flags, diffuse British flag and Iraqi flag or Turkish flag, and let them to put into the ballot box. And again, they certainly refused. And as you mentioned, it is a colorful geography. Turkmens, Kurds, Arabs, Christians, Yazidis, people living there, and multiple languages. Turkish language at the center of the cities of the region, mainly, and during the main road, and other languages were also in use. But there was no ethnic conflict among those people until the decision, final decision of the international community. This decision, unfortunately, could not bring peace to the people living there. And there is also foresaw a sentence forecasting the future, saying that the Iraq would be unstable because of its internal problems. The Commission said that. If the option of union with Turkey would be preferred, certainly the people of Mosul would have a more stable system on top of them. So the history, a century of history of Mosul Vilayet territories, unfortunately, showed that this forecast was true, because we still see internal strife, rise of ISIS and the other sort of clashes. The decisions of international courts can touch the lives of people during generations, not just the lives of a generation, but subsequent generations. Thank you very much for this knowledgeable and valuable presentation. Any other questions from the conference hall or from the internet on this issue, on the interpretation of Lausanne Treaty? Sorularınız var mı arkadaşlar? Makale hakkında veya yorumlarınız. Okay. If not, thank you very much.
Thank you so
Hope to
much.
see you Istanbul soon.
Yes, I hope so too. I will be back with the Lotus.
Okay.
Thank you. This will be the end of our conference. If you excuse me, I will end the session now. Thank you so much.
Thank you. Thank
Nice to meet you.